Donald Trump's motion to dismiss his felony conviction in New York has just been denied by Justice Merchan. Justice Merchan found that Donald Trump's conduct does not constitute official acts under the Supreme Court's absolute immunity doctrine. In the alternative, Justice Merchan said even if it would constitute official acts, the testimony regarding official acts, which it was not, would constitute what's called harmless error under the law, and therefore the motion to dismiss the criminal convictions would still be denied, even if they constituted official acts that came in as evidence. Let's just go through this 40-plus page ruling together, just to give you a reminder of what took place. Donald Trump was convicted in a Manhattan criminal courthouse on 34 separate felony counts for falsification of business records. Then the United States Supreme Court made a ruling regarding absolute presidential immunity. And not only did it find that core constitutional functions and official acts should be given absolute immunity, but evidence that's introduced regarding potential official acts would have to be excluded if it was introduced. So Donald Trump said, look what the Supreme Court ruled, Justice Merchan. There was some evidence in this case that related to official acts, things that went down in the White House. Trump argued that his Twitter posts, which came in as evidence, constitute extraordinary official acts of the presidency when he was in office. Justice Merchan shot down each argument, said that if there was a typical example or a hypothetical where conduct would constitute unofficial acts, it would be a case involving this case here, a hush money payments case, which is clearly unofficial. Justice Merchan said, private conduct, nothing to do with the presidency. Let's just go to the last page of the ruling, page 40 and 41, so you can see the judge's conclusion. This court finds that defendant preserved his claims only as to the testimony of Hope Hicks OGE Form 278E and Twitter postings identified as People's Exhibits 407F through 407I. All other claims are denied as unpreserved. Let me just tell you what that means. Justice Merchan said that Donald Trump's lawyers did not even properly object or assert potential immunity as a ground, and therefore they waived the issue. But then Justice Merchan said, look, even if there was not a waiver, remember there's these two instances too where Justice Merchan say that objections were preserved, but he goes, as to all of the conduct, even if you preserved the objections on the basis of absolute presidential immunity to the introduction of evidence, he went on to analyze it, said this is not official conduct. Then he did a third tier analysis. Even if official conduct, it's harmless error. You lose for three reasons, right? And why is Justice Merchan going through all three reasons? He knows Donald Trump will immediately appeal this to the United States Supreme Court. We'll go through the New York court system first, then the Supreme Court. So Justice Merchan wants to make sure all arguments are fully briefed and that it is entrenched in these three different rulings. Let me go on and read page 40. This court further finds that evidence related to the preserved claims relate entirely to unofficial conduct and thus receive no immunity protections at all. And as to the claims that were unpreserved, the court finds in the alternative that when considered on the merits, they too are denied because they relate entirely to unofficial conduct entitled to no immunity protections. That's where a judge saying, look, even if you find that his objections were preserved, I'm not going to lose this ruling on a technicality. The judge is saying he still loses. Those are unofficial acts there. Justice Merchan goes on to say further, even if this court were to deem all of the contested evidence, both preserved and unpreserved, as official conduct falling within the outer perimeters of defendant's presidential authority, it would still find that the people's use of these acts as evidence of the decidedly personal acts of falsifying business records poses no danger of intrusion on the authority and function of the executive branch, a conclusion amply supported by non-motive related evidence. And lastly, this court concludes that if error occurred regarding the introduction of the challenged evidence, such error was harmless harmless in light of the overwhelming evidence of guilt. Overwhelming evidence of guilt. So Justice Merchan says, even if all of the analysis I gave you is incorrect, and you said that this other evidence was introduced inappropriately, which it was not, because it was not official acts, that didn't make a difference. There was overwhelming evidence of guilt regardless. Lastly, the court concludes that if error occurred regarding the introduction of challenged evidence, it was harmless. Goes on to say, defendant's motion to dismiss the indictment and vacate the jury verdict pursuant to CPLE section 330.3-1 is denied. The foregoing constitutes the decision and order of the court. The court, in an earlier page on pages 17 and 18 says, it is therefore logical and reasonable to conclude that if the act of falsifying records to cover up the payments so that the public would not be aware is decidedly an unofficial act, so too should communications to further the same cover-up be unofficial. So Justice Merchan says, first, I'm going to be finding that the falsification of records, it's unofficial. And so if that's unofficial and that conduct predates him going into office, any subsequent conduct, the cover-up of the unofficial acts is unofficial acts if we're being logically sound here. Justice Merchan on page 17 says, going over the Supreme Court ruling, in the Trump Supreme Court case, the majority identified only one instance of official conduct entitled to absolute immunity and remanded the matter for the district court to conduct the remainder of the analysis as to all other conduct at issue. The court provided guidance to the district court to assist in differentiating between official and unofficial acts, noting in part that it is the nature of the function performed, not the identity of the actor who performs it, that informs our immunity analysis, as noted by Justice Coney Barrett. Notice too there how smart Justice Merchan is. He's not citing any of the Democratic appointed justices. He's going right to cite a justice who Trump appointed, as noted by Justice Coney Barrett in her concurrence in part, in the absence of precedent directly on point, the use of a hypothetical is a highly useful legal tool, and one would be hard-pressed to devise a hypothetical more on point to guide the analysis between official and unofficial conduct than the case at bar. Is a president's in-office conduct to conceal payments to an adult film actress to keep information from the public eye relating to an encounter that occurred prior to his presidency, official or unofficial? And Justice Merchan answered the question, unofficial. And then the cover-up, unofficial. Justice Merchan then went on to analyze the testimony of individuals who potentially could have had official conduct, like Madeleine Westerhout, who was the special assistant to the president, and she testified about the process of bringing mail into the White House and how Trump would deliver mail. Justice Merchan then talks about Hope Hicks' testimony, and then Justice Merchan talks about defendant's Twitter post and Michael Cohen's testimony, and Justice Merchan says, you go through all of this, all of the cover-up of unofficial acts equals unofficial acts. I'm not persuaded. And remember, earlier on in his ruling, Justice Merchan said, as to most of these, y'all didn't even file the appropriate objections. So you didn't even preserve the objections. But I will go on and do this analysis as if you did give the appropriate objections and assert absolute immunity when you could have. And then he says, now that I've done the analysis, still unofficial. Now that I've done the analysis, even if they were official, harmless error, there was overwhelming evidence of guilt even outside the testimony and the Twitter posts of people like Westerhout, Cohen, Hope Hicks, and those Twitter posts. So there you have it, folks. Justice Merchan ruling Trump did not have absolute immunity. Now we go on to the next question. By the way, we were accurate about what Justice Merchan was going to rule here. He was very strong in his ruling. The next step that we have to figure out is sentencing. What's Justice Merchan now going to do about the sentencing? Does he stay or delay it because of the election? What happens? But big news, big update. Let us know what you think. Hit subscribe. Let's get to 4 million subscribers.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.